You have built a thriving tech startup, and now you are scaling your operations into the New York market. High growth potential alone won't get you through the border. One misplaced checkmark or missing document on your immigration paperwork can result in a permanent denial, shutting down your expansion before your plane even takes off. I am Norka M. Shell, founder of the law offices of Norka M. Shell. As a dual licensed attorney in New York and Brazil who has personally navigated the U.S. immigration system, I guide entrepreneurs through these exact challenges. To secure your 2026 expansion and navigate these specific bureaucratic hurdles, you must master 3 strict legal requirements of the L1 visa. The process does not actually begin in the United States. It starts at your current headquarters, whether that is in Sao Paulo or another major hub, because you must have a successful, active company operating abroad. USCIS dictates that your new U.S. office cannot be an isolated entity. There must be a direct equity link between your foreign parent company and the new U.S. subsidiary. USCIS requires heavy documentation to prove this connection. You need to provide stock certificates, articles of incorporation, and ownership registries. And this connection must be maintained. The foreign company has to remain fully operational and actively doing business for the entire duration of your visa. If you cannot produce an airtight, provable corporate link, the legal foundation of your petition collapses, and any further steps are irrelevant. The most frequent error that derails Brazilian tech founders is failing to prove their exact role. You must operate strictly at an executive or managerial level. This pyramid illustrates USCIS standards. You must show you direct the organization, establish broad goals, and operate without heavy supervision. Alternatively, managerial capacity requires you to manage professional tier employees or oversee a critical function. Timing is strict. You must prove you held this high-level role at the foreign company for at least 1 continuous year right before you file. Many founders fail the review by acting as a functional manager. If your daily duties involve writing code or making direct sales calls, the government will deny your petition. The U.S. government grants this visa specifically to strategic leaders who scale operations, not to operational employees doing the groundwork. Once your background is verified, the focus shifts to your U.S. destination. You need a legitimate physical footprint. Before you even submit the petition, your startup must have secured enough physical office space to house the new operation. If your U.S. branch is less than a year old, you are subject to the new office provision. This means your initial visa is probationary and granted for only 12 months. Here is a 12-month timeline chart plotting the necessary milestones. You must submit an aggressive, detailed business plan that proves your U.S. entity will hit the necessary capital injections, hiring quotas, and revenue thresholds to actually support an executive role. At the 12-month mark, you must prove you successfully executed that exact plan to secure your long-term visa extension. USCIS treats this visa as a direct investment. You have to demonstrate the physical and financial capacity to stimulate the U.S. economy from day one. Treating your 2026 L1 visa as a strict 3-pillar business project transforms a high-risk gamble into a methodic expansion process. This is how you arrive at the gate, holding the legal credentials of a New York-based business operator. Scaling a multi-million-dollar tech company to New York cannot rely on guesswork or generic legal templates. Click the link in the description to book a private, strategic L1 mapping session with the law offices of Norka M. Shell. Make sure you subscribe for more elite immigration strategies tailored specifically for foreign founders.